Hi there. What's new? Me, just back on my way back to the office from visiting a client who had some intellectual property questions, and that kind of struck me that this might be worth sharing. One of the things you don't get a lot of training on out there is how to brief a lawyer. It's one of those things that I guess you only get through experience of having been through the full life cycle of having briefed them and then having to live with the consequences of that. So thought it might be worth sharing. Intellectual property protection from a legal standpoint. There are really only three reasons for looking at intellectual property protection. And forgive me if I'm a little cynical on some of these, but you know, it pays to have some outlook. Number one, trying to keep your competition out of the market. Great. Number two, increasing the value of your asset portfolio, selling to somebody else. There is no value to an asset portfolio unless you're selling it. It's the value in their hands. I'll come back to that. And the third one, easiest one of all, is government funding, government programs, tick in the box. Okay. What I'm going to tell you in this is basically, unless you are one of those exceptional organisations, which I may talk about in a moment, chances are you really need to be looking at this, keeping your costs to a minimum. I'm not saying don't do it. Do it. It's important to do, but understand what you're trying to achieve and the value of what you can achieve by actually undertaking this work, and don't spend more than you need to. So we'll start with reason number three. Having intellectual property protection, if you are looking at R&D funding, that kind of funding, tick in the box, very important to do. The chances of them ever reading your application, having looked through it in detail, almost nil. Sorry to my friends in government, but happens to be the case most times. Anyway, so, you know, don't sweat it too much there. Tick. Sale. If you're going to sell, one of the assets that you're selling is the value of your portfolio, and it is the defensibility of that in the hands of your acquirer. Now, sure, you read a lot in the press about the Apples, the Googles, the Motorola's, the Microsofts, etc., battling each other in court. Look, that's all fun and games, but unless you actually have the bankroll to be able to play that game and to be playing the argy-bargy they're playing with each other, it's got very little value in your hands. Not all acquirers and not all businesses are likely to be sold to that kind of acquirer. Have a think about who realistically may be able to be procuring your business, your intellectual property, and think what it's like in their hands. You do not need to take intellectual property to the full extreme. You need to provide a reasonable groundwork, some framework. It might just be a provisional patent. It might not be the full thing. It might not be global protection. I mean, it's all about timing in this instance. But do no more than reasonable groundwork to make it valuable. Whoever buys it, if they are buying it to value, will see and will understand and will have the resources to invest in perfecting that patent to the extent that they need to for the games that they want to play. Let's bring that back to the last thing, because the last thing is about keeping your competitors out of the market. And look, the big boys are doing it to keep their competitors out of the market, and they're doing it by frightening each other with massive lawsuits, hundreds of cross patents, etc. It's a huge game. But in your own hands, again, unless you're a company who this does not apply to, most of us are not in a position to actually see a patent infringement litigation all the way through to extremes, through to the end. Now, there are some examples of people who have made a lot of money by doing this, and there are, lots of cases, but they are in the minority. Generally, the vast majority of patent infringement litigation are not seen through to completion. It is just too expensive. What you want to do is to try to frighten them away. Now, if this is software particularly, it is incredibly hard to get patent protection for software. Again, those court cases are rarely won. It is far too easy for people to make the 10, 15, 20% changes that's required to say, hey, you know what we're doing, this is new stuff. Far too easy for that to happen. What you want, again, is a reasonable basis to send what you can afford, which is going to be a nasty legal letter. Nasty lawyer's letter saying, hey, bug off out of this space or I'll do worse. But In reality, chances are you won't. So don't think about this as an investment in the overall value of the asset. Think of it in terms of what it is going to play in terms of your ability to protect this in court and the likelihood of you actually taking it all the way through the process. The very, very unlikely chance that you will take it all the way through the process and into court. Look, that's just some background, and look, all of this varies depending on who you are, large organisations, small organisations, whether you're actually building a massive IP portfolio, wherever you're coming from, what type of R&D you're doing, what type of field you're in. It just gives some background to some thinking. Take it in mind. Good thinking. Have some fun. See you around.